Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
28. Thank you, Ms. Franklin. You may have a seat. Is the oldest case that is currently on the court docket. Do we have any resolution of the case today, Mr. Carnes?
Yes, Your Honor. It's my understanding that Ms. Franklin will enter a guilty plea to an added count of disturbing the peace, and the people will dismiss the charge count and the habitual.
Mr. Burdett, is that a complete and accurate statement?
Yes, it is, Your Honor.
Ms. Franklin, is that how you wish to resolve?
Yes, sir.
Right hand. Do you swear or affirm the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
I do.
You may lower your hand. Excuse me. All right, Ms. Franklin, you are currently charged with aggravated stalking, which is a felony punishable by up to 4 years and or up to $10,000, plus probation for any term of years, but not less than 5 years. Plus, there's a fourth habitual felony offender enhancement that could have made that maximum punishment up to life, but the prosecutor's given you the lowest misdemeanor he possibly could, which is disturbing the peace. It's a misdemeanor punishable by up to 90 days and or $500. If you plead guilty to the added count 2, the prosecutor will dismiss the original offenses. Is that what you understood to be your pretrial agreement today?
Yes.
By entering a plea of guilty today, you'll not have a trial of any kind. And the trial that's currently set for October 28th will not take place. By pleading guilty, you'll be given up certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to make silence during the trial, the right to not have silence used against you, and the right to testify if you were to choose to testify. Ms. Franklin, do you understand those rights?
Mm-hmm.
And you understand that if you plead guilty and I accept that guilty plea, you will be forever waiving those rights as they apply to this particular case.
Mm-hmm.
Additionally, you may be given up, the right to claim that the plea was a result of any promise, threat, or inducement not told to the court today on the record. Have there been any other promises, threats, or inducements to get you to plead guilty as we discussed?
No.
Are you entering the plea of your own free choice?
No.
Now, there has been no mention of any promise as to a sentence. Has anyone told you or made any promise or asserted to you exactly what they thought or what they suggest will be the sentence? Has anybody told you what I will do?
No. I don't know what you're.
Or do you still wish to enter the plea of guilty as we discussed earlier? As to add count 2, disturbing the peace, how do you vote? How do you plead? Before the court can accept your plea, I must have you tell me what it is that you did that makes you guilty of that offense. Turning your attention back to a date range of February 28th of 2024 and March 19th of 2024 in the city of Cadillac in Wexford County. What did you do?
I get my groceries delivered, so I pounded on a wall and called the landlord, called the police, and yelled and screamed.
So, time you were living over on Farr Street, is that correct? And you said you could not get groceries delivered? Explain that to me.
I had to go through a company to have groceries delivered, and there was no way to drop them off at my house.
Okay.
There was too many cars parked on the side of the house for them to pull up.
All right.
They didn't want to walk 3 blocks to bring them.
Okay. So, and then, so what did you do when you found out they could not deliver your groceries?
Called my neighbor and asked him if they would move a car up, and he said no. He said fuck off.
I'm sorry? I'm sorry. 901 Farr Street has apartments in a residence, like a house? Okay, and so you left your apartment and went to one of the other apartments and pounded on the door?
No, sir, I went downstairs to look, because the driver of the groceries called me, said he couldn't deliver them. So I went downstairs to look why, and there was a bunch of cars on my side of the house. And so I pounded on the wall, hollered through there, "Are those your cars?" He said, "Yes." I said, "Could you please move one up?" He said, "No." He said, "Fuck off."
Okay,
And I went upstairs and I called Mr. Jewett and I told him, I said, "Can you just move one of the cars up so I can have the groceries delivered?" And he said, "F off again," and I got mad.
okay. So you got mad, and what did you do?
Screamed at him.
Okay. And did this just happen all in one day?
Yes, sir. I hadn't been getting along with him. It was just problem after problem. I should have moved out.
Okay. Then what was it that you were screaming? If you could please explain that.
That I hoped he choked on his food.
Okay.
I hope the rest of them got into car accidents and hit semis.
Mr. Carnes, do you believe any further questioning needs to be asked? Mr. Burdette, do you?
No, sir.
Mr. Carnes, I believe she provided a factual basis to support the added count.
Yes, Your Honor.
Mr. Burdette, do you?
Yes, sir.
Mr. Carnes, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with Commission Rule 6.302?
Yes, Your Honor.
Mr. Burdette, do you agree with those last two statements?
Yes, I do, Your Honor.
All right, thank you. The court agrees and finds the defendant's plea is made freely, knowingly, and voluntarily. Court further finds the testimony provided by the defendant under oath on the record satisfies the elements of added count 2. Therefore, the defendant is found guilty of added count 2, then count 1, and the enhancement will be dismissed. Are we able to proceed to sentencing now that it's no longer a victim impact offense?
I believe so, Your Honor, yes.
Mr. Burdette, do you have any objection to proceeding to sentencing today?
No, sir.
Thank you. Allocution then, Mr. Carnes.
Thank you, Your Honor. It's clear that Ms. Franklin disturbed the peace based on her yelling and pounding on the wall. I ask the court to issue an appropriate sentence in light of that. Thank you.
Do you have any information about her prior criminal history?
Yes, Your Honor. Your Honor, I am told the victim would like to speak. However, I do recognize the way it's.
Right, that's fine. I'll allow it because it's
Thank you.
based upon, this is the landlord? I'm sorry, but I don't remember where he lives. Is he a landlord? Is he the tenant? I don't know. Thank you. All right, you may come forward.
Thank you.
Sir, you may approach this, the podium and then tell me your first and last name.
Bruce Jewett,
Spell the last for me.
Jewett.
Yes, sir. What is it you'd like to say?
Well, there's been a lot of half truths, what she said of her stories, but a lot of it's been made up on her part.
Oh, the prosecutor's the one in charge of the case. This is what they think happened.
that.
This is what they've chose to do if it was a potential life offense. But go ahead. That's okay. I'm not picking on them.
Okay.
That issue would have to be taken up with them, but go ahead, sir.
What we're talking about is she's threatened me throughout that whole time of stuff like that. And pounding on the wall and coming to a window and pounding when my grandkids were parked. I had my grandkids over for dinner parked on 6th Street. She came home in a Wexer ride. And she said she couldn't walk very straight into her apartment. She went off like Tasmanian devil, pounding on my window and swearing at us through the screen. It's illegal parking. They didn't want us parking in the driveways. They parked on the side, out on the side street on 6th Street.
Who's they?
My grandkids.
Okay.
Well, I called the police because she was doing all kinds of threats to me.
And you live in the same home, right? But in a different apartment?
Yeah.
Okay.
She lives in the front upstairs and I lived in the back downstairs.
Okay.
As far as me blocking the driveway, that's so untrue. She had a vehicle there that wasn't legal, and she couldn't get out, but we never blocked it. Just, you know, I fear for my life because she's threatened me several times, you know, killing me. And I know where your friends live, all that kind of stuff. I mean, she's a very disturbed woman and she needs some help.
All right, thank you, Mr. Jewett.
Thank you.
Mr. Carnes, the criminal history.
Yes, Your Honor. I would also like to thank Mr. Jewett for speaking. In 1981, the defendant was convicted of uttering and publishing. In 1982, defendant was found guilty of shoplifting and another uttering and publishing. In 1984, she was found guilty of assault and battery and disorderly conduct. In 1993, she pled guilty to operating while intoxicated, second offense. In 1994, she pled guilty to assault with a dangerous weapon and uttering and publishing. In 2013, she pled guilty to misdemeanor stalking. In 2021, she pled guilty to malicious use of a telecommunications service. And in 2020, she pled no contest to malicious use of a telecommunications service. In 2020, she pled guilty to attempted uttering and publishing. In 2022, she pled guilty to operating a motor vehicle without security. And that is everything I show for the in-state criminal history round.
Thank you. All right, Mr. Burdette, allocution, sir.
Yes, Your Honor. Your Honor, my representation as Margie Franklin, you know, she felt that she was threatened. She left her residence because of not getting along with Mr. Jewett. And I think when the court found her in contempt, I think the court sentenced her to 70 days in jail at this point. My client, what I would request the court do is to sentence her to 70 days concurrent with the original contempt charge. I believe this time in jail, she has a lot of health problems. She needs to go to Mayo Clinic because of her legs. And I know the court is aware of her various health issues that she's had throughout this case. And I think the soonest that she gets out of jail to be able to address those, the better it would be for her health and her mental health. Yeah.
Thank you. 1 second. I had a question for Mr. Carnes. Can't remember it. All right, thank you. Ms. Franklin, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say today?
There is, sir.
Okay, go ahead.
First, I'd like to apologize to you and the court members here for the disrespect I showed on April 8th. I'd like to apologize to Mr. Jewett for anything he thinks I've done wrong. And I have since my son's death, and I didn't realize it until this time in jail. I've been running on guilt and anger about different issues, which I have to address myself in an appropriate way. I've let it affect everything in my life. So if Mr. Joe really does feel that I would harm him, I won't. I made him feel that way, and I'm sorry he made me feel the way he has to make me leave my home. I have lost everything, my entire family, everything over all this. And I want it to be over. A patient with the Mayo Clinic that's out of state, and I would like to go as soon as I can and not come back. I don't know if I'll ever see my grandchildren again. They were just adopted last week. These are my losses that I guess I created over all this. I just wanted a home. I just wanted to be okay. That is all. Thank you.
Thank you. Mr. Carnes, you know, I've got to give credit. And hold on, Madam Clerk, maybe you can help me figure this out. When were we last back here in court? I see that she posted bond back in April 22nd of last year, so she had 4 days then. At least 2 days now, so I'm going to give 6 days of credit. All right. Well, the court's not going to put you on probation. Now, it's not worth it. You've got somewhat of a criminal history involving a lot of stuff with crimes of dishonesty and other issues. And here, as I talked about last time, we had a trial date, and this court did a lot to accommodate every other issue you had in the past. And when you ran out of having medical issues, we told you to come, and you said no. I actually heard the phone call. So you didn't coordinate with anybody. You didn't help. You didn't have to stay at the home. Wherever you went, you could have gotten a ride back here. Ms. Franklin, everything here in your life that I've seen so far is a product of, a lot of it is your choices on how to react to challenges in life. And I'm very sorry for the loss of your son and other challenges that you had. And I was very accommodating. The court was very accommodating with all the adjournments that you requested. And yet I'm pretty certain I've also heard where you continued to call the offices and clerk's offices to complain about stuff. I just don't understand it. Now, that has nothing to do with this offense, but what it tells me here is you will do what you want anytime you want to do it, and you will justify your actions. Even when people are polite to you, even when people give you graces, you choose to do what you want. Court sentences the defendant to a $50 state minimum fee. Is it 50 or $75 crime victims' right fund fee. I'm going to assess $100 court cost. No fine. I'm going to assess a $300 attorney fee. Mr. Burdett's appointed. There are no supervision fees. There are no DNA fees. However, the court, based upon the nature of your criminal history, the nature of the repetitive types of criminal history that you've got, your non-compliance with bond in this case, the court sentences you to, and I will be concurrent, 90 days in jail with 6 days of credit, and that will run concurrent with the contempt charges. Thank you. Have I missed anything, Mr. Carnes?
No, Your Honor.
Have I missed anything, Mr. Burdette?
No, sir.
Thank you. We're adjourned. All right, our next file this morning is People of the State of Michigan versus Justin Griffer. It's going to be case number 25-14036.